Welcome to Immigration Explained Simply.
Hey everyone, welcome into the first episode of Immigration Explained Simply with attorney Aisha Nanyanzi. I am your host, Mike Leon. You know, Aisha here is the founder of AKN Immigration based out in Gilbert, Arizona. She's been serving clients nationwide and abroad, and she's gone through the U.S. immigration system herself. So she brings both the legal experience and personal understanding to the work that she does. Today's episode, we're going to be talking about marriage-based green cards. Aisha is going to explain what the process generally looks like today, what can complicate it, and what families should understand as they move forward. Aisha, it's so good to see you. You know, immigration is such a hot topic right now in the news with respect to everything that's been happening nationwide, enforcement, et cetera, et cetera. So we'll leave it there. But I do want to ask, before we even dive into the immigration stuff, since this is your first episode, can you kind of share a little bit about your background, what led you to focus on immigration law and particularly family-based cases?
Thanks for having me, Mike. So, my background a little bit, I'm originally from Uganda, and I came to the United States and went through the immigration system myself. I was an asylee, and I worked with an immigration attorney at the time down in Boston who helped me with my case. Luckily, after I won my case, he hired me to work for him. We were really based on humanitarian immigration, family immigration, and that is what we were doing a lot of. So I was a paralegal there for a little over 8 years. And at some point in between, I decided to go to law school because I wanted to do more than be a paralegal. I wanted to advocate for clients directly and go to court. So that is how I ended up being an immigration attorney. And that is precisely how I ended up choosing to do the family and humanitarian immigration.
Well, it's a great story, and I applaud you and commend you for your work. So let's dive into your subject matter expertise. I mentioned in the intro about marriage-based and green cards. So what does that process look like today? How does it differ depending upon whether the applicant is in the U.S. or somebody that's applying from abroad?
So the marriage-based green cards do differ when you're applying from the US and when you're applying from abroad. When you are applying from the United States, there are a set of requirements that you must meet. One being that you must have been lawfully admitted or paroled, and two, that there are no inadmissibilities, pretty much. Those are the two major ones. So basically, you need to show that. And the way that process works, assuming you are married to a US citizen, you would be an immediate relative. And you can simultaneously file the I-130, which is what the US citizen files for their spouse. And then you also file the green card application, which is the one that gives you the lawful permanent residence. When you are outside the United States, the way it works is the US citizen files an I-130 petition for you. And once that's approved, it is sent to the National Visa Center where you go ahead and apply for an immigrant visa. The immigrant visa pretty much is what we would equate to a green card, but you're applying for it at the consulate.
Aisha, can I ask you, because my understanding is that there are some marriage-based green cards that are conditional. Is that correct? Can you kind of explain when a green card is considered conditional?
Yes, some marriage-based green cards are conditional, and those are for 2 years. And within the 3-month window before that green card expires, you have to apply to remove conditions on your green card. So basically, how that happens is if at the time of approval of your green card application, you have been married for less than 2 years, then you are going to get a 2-year green card. If you have been married for more than 2 years, then you will get a 10-year green card. So that is basically what differs at that point.
And you know, we're talking about marriage, but divorce is very common here in the US, unfortunately. And that's got to be, I'm sure, one of the biggest concerns in these cases. What kind of happens if someone's immigration status, the marriage ends before the conditions are removed? Like, how does that affect the divorce?
The divorces are very common, as you have mentioned, Mike, and that is one of the things that we try to explain to clients. So basically, what happens is when it's time to remove conditions for your green card, there are a number of ways that you can remove them. It can be a joint petition if the spouses are still married, but you can also remove it with a waiver if you entered the marriage in good faith, but it ended in divorce. So they are not penalizing you for getting out of a marriage that's not working. You just have to show that at the time you entered the marriage, it was in good faith, and then you show a divorce certificate. And that is all that you would need to show.
Another thing that I'm sure is common that's brought to you is death, unfortunately, right, of the U.S. citizen and the petitioner. So, what are options that exist for that immigrant spouse in that unfortunate circumstance?
So, in the unfortunate circumstance like the US citizen petitioner dies, it depends on what stage you're at um, in the marriage. So, if you get married to your US citizen petitioner and they die before they file the I-130 petition, then at that you can file the widower petition, which is a different petition. You show that you were married to this US citizen, they died less than 2 years ago, and now you're filing to get a green card because your US citizen spouse is deceased. Now, if the I-130 has already been filed but has not yet been approved, then you can ask USCIS if they do not automatically convert that I-130 into a widower petition, then you can ask them to convert it into a widower petition. Now, the other situation is where the US citizen dies after the person got a conditional green card. This person got a conditional green card and the US citizen dies in between, then they can file for that petition to remove conditions on the green card by themselves because they entered the marriage in good faith, but the US citizen petitioner died. And the thing with that is they don't even have to wait for that 3-month window. If the US citizen petitioner dies, they can file immediately and then also show the death certificate.
All these petition numbers, I-130, I don't even think we even talked about the I-751 petition. Can you kind of explain what other forms and petitions that people need to know as kind of an explainer for them?
So the I-130 petition is the petition for alien relative. Basically, you are using this petition, this form to petition for your spouse or your parent or your child. So you use this form, you even use it to petition for your brother and sister if, again, you are, it's a qualifying relative. So basically, the I-130 belongs to the petitioner, either the green card holder petitioner or the US citizen petitioner. Now, the I-360 in this situation that we are using as the widow petition is basically a form that's used for a bunch of different petitions. It can be used for a VAWA petition, it can be used for a widow petition. We have the special immigrant juvenile, but for our purposes, let's just keep it at the widow petition and the VAWA self petition. The I-751 is the one that we use to remove conditions on the green card or on the permanent residence. This is the same form that we use whether we are jointly petitioning with our spouse or we are self-petitioning, where the person who has whether the conditional resident is self-petitioning, either because the spouse was abusive or because the spouse died or because the marriage ended in divorce. It would still be the same form.
So many numbers, so much information. I'm glad you're explaining it all. But Aisha, you did mention something there about qualifying children. So let me ask you about that. What about stepkids? Like, how are they treated in some of these marriage-based green card cases? What are some factors that usually matter when determining whether they can be included or other non-qualifying members can be included or petitioned for?
Stepchildren can be petitioned for by the US citizen spouse, but there is a caveat to that. One, the marriage between the parent and the US citizen spouse must have happened before the child turned 18 years old. So that is what triggers the step-child relationship for immigration purposes. Then they should not have turned 21. If we're going to basically consider them immediate relatives, if they are a child, and they should be under 21 years old.
Aisha, as we put a bow on this first episode, when you look across all of these scenarios that are playing out, we mentioned a bunch applying inside, outside the US, divorce, death of a petitioner. Why does the understanding of the process early on help people? Why does it make a difference in how these cases unfold? Does it make a difference in how these cases unfold?
It really does, because you need to understand your options early on before you file. And by understanding your options, it saves you time, it saves you money. It makes you, it basically manages your expectations, right? Now, you can file for a child who is above 21 years old. You can file for a child who is married. You can file for a child who is unmarried, who was divorced, but the processing time differs in all of that. A child who is married is not considered an immediate relative. A child who is over 21 is not considered an immediate relative. You can file for your sibling, but you understanding that only US citizens can file for their siblings. You can file for your parent, but you understanding that only children over 21 can file for their parents. All of that matters, because if you're 18 and you just file for your parent and that petition is denied, you've wasted time, you've wasted money, because there is filing fees associated with all these forms. So you understanding your options early on saves you a lot of time. We've had situations where we have to file the VAWA self petition, which is basically the self petition based on abuse of a qualifying relative. People understanding these situations has helped them get out of abusive relationships, get out of unsafe environments. So, really understanding your options off the go really, really helps.
Yeah, it really does. Aisha, thank you so much for the time, the insights, explaining all this to the audience and introducing yourself to the audience. We appreciate it.
Thanks for having me, Mike.
And thank you to everyone out there for listening to this installment of Immigration Explained Simply. If you'd like to learn more about marriage-based green cards or other immigration options like Aisha mentioned, do me a favor right now, visit immigration.com to explore all the resources, schedule a consultation with Aisha and the team. Do me one more favor as well before you go. Hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. I am Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.